emphatically.
Please, Your Worship, my name is Elias, appearing together with the following counsel for the accused person. That is, the respondents. We have Mr. Mpanga, Mr. Sekanja, Mr. Kurunzi, Kizza, Martin one, sorry, Ronald one, son. Katot Musima. We are ready to receive them, Your Worship.
This is a ruling. Counsel for the accused made an application before this court that I recuse myself from handling miscellaneous application number 1 of 2025. Before court can pronounce itself on the application for recusal, there is need to determine whether this court has jurisdiction to entertain any application arising from the criminal case where the accused has been committed to High Court. Jurisdiction is a creature of statute. A decision by a court without jurisdiction is a nullity. Once the court finds that it has no jurisdiction to decide a case, it cannot take any further step in the case. The accused persons in criminal case number 8 of 2025 were committed to High Court on 29th May. This court, having committed the accused persons to High Court, does not have jurisdiction to make any decision or order after the committal proceedings. This court can thus not make any decision on the application for recusal because it has no jurisdiction to do so. The committal proceedings in criminal case number 8 having been concluded on 28th May. Accordingly, the accused is further remanded awaiting trial at High Court.
They have just been wasting our time. Obviously, it's no brainer
and it's obvious that once one has been committed to High Court for trial, you cannot reopen the case for investigation. It's no brainer. Even an ordinary person, a lay person would know this, that the jurisdiction of this honorable court is exhausted at a time when committal proceedings are conducted. In other words, we have a doctrine of functus officio. Once the lower court has exhausted its powers, its jurisdiction, its mandate, it becomes functus officio. In other words, its hands are tied. You have no choice but to terminate the proceedings. So that is the thing. This magistrate had no choice but to terminate all the proceedings relating to Dr. Besigye's case after conducting the committal proceedings on the 29th of May. And this is been actually waste of time. But on the side of the case, in regards to the merits of the matter, the substantive case before the High Court right now, it's a huge blow to the state, in that they wanted this evidence to support their charges. And it's the reason they put in this application, so that court could issue an order to allow them access the data on Dr. Besigye and Obeid Lutale's phones, which court has now rejected because they have no jurisdiction. Obviously, as we explained, they had a dilemma. They were in a catch-22 situation. They were placed between a rock and a hard surface. They had 6 months within which to conduct the investigations, which lapsed on the 20th of May. But at that time, by that time rather, they had not exhausted all the investigations. And all they had to do is to admit Dr. Besigye on mandatory bail in accordance with the provisions of Article 23 of the Constitution. Yet they never wanted Dr. Besigye released. So they had to keep him on remand under all circumstances. But their time had run out. They had to close the case at that time. But they still had a pending application to access data, which they had to pursue. And there was no way they could still keep Dr. Besigye on remand after the expiry of the mandatory remand period of 180 days. So that's the catch-22 situation they had to deal with. So they wanted two things. One, to have Dr. Besigye on remand, but at the same time continue investigations even after the mandatory period of remand. They couldn't achieve both. So they had to go with one of the two. Either you have Dr. Besigye released on mandatory remand and continue with investigations until such a time when you are done and ready to proceed with the hearing, or you have Dr. Besigye committed to High Court for trial and you forget all about the evidence which you wanted to substantiate your case. So that's where they are. So now where we stand today, they cannot have this critical evidence that they wanted to support their case. Because now the magistrate has, and rightly so, decided that she has no jurisdiction because she is functus officio, she exhausted that jurisdiction, and therefore they cannot proceed with the application to access Dr. Besigye's information. And that has far-reaching implications on the merits of the matter because they badly needed this evidence to support the charges before the High Court now. So that's the call we are making now that their case is hollow. They should have it withdrawn. It should be withdrawn because without this critical evidence, it's an exercise in futility for them to proceed with the prosecution. It's no brainer again to say that they have no case against Dr. Besigye without this kind of evidence, which they badly needed. And they cannot have it. It's a fait accompli now, it's gone, totally gone. Because the High Court cannot open even the slightest window of ventilation to allow them smuggle in this evidence. It's not possible. Kaput. So the case is completely kaput. The reason they should release Dr. Besigye. That said, for us, we are proceeding with the application for mandatory bail, which we filed upon the expiry of 180 days on remand. It's now pending before Justice Baguma, only that we need to deal with the issue of management of the two files. The substantive case is before the ICD. Yet the application for bail is in the criminal division. So we are going to sort that out administratively and have this matter fixed for hearing so that we can have Dr. Besigye and Obeid Lutale released.